right, the right and the left.
Oh,
Yes. Yeah.
Well, the one in the middle is always there.
That's the only one. Yeah.
Okay.
And Charlotte and
Charlotte.
These are the same. Yeah.
Okay, I know Mouse was there.
Yes. Ariane noticed. She said the right and the left. Maybe in Warner or New. Warner. As in the Chief Justice.
Yes, no, wait.
Just say it, Sid.
I know,
Just
you're
say
so
it.
senior. You just know so many people there.
Look. That's how old I am.
I know. Well, that's just how senior you are. And the rest of them, the rest of the houses.
Court, all rise, please. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Well, good afternoon to you all. What a glorious day today is. Welcome to the Massachusetts Appeals Court. My name is Ken Desmond Jr. I'm an Associate Justice of the Appeals Court, and I'm President of the Harry J. Elam Judicial Conference, formerly known as the Mass Black Judges Conference. On behalf of the Harry J. Elam Judicial Conference, it is my privilege and honor to welcome you here today for a long-awaited and overdue occurrence, the unveiling of the Justice Fred Brown. For those of you who may not be familiar with the Harry J. Elam Judicial Conference, as I mentioned, it was previously known as the Mass Black Judges Conference and was renamed when the conference opened its membership from black judges to include all judges of color. It was renamed after the first black Chief Justice of the Boston Municipal Court and founding father of the Mass Black Judges Conference, Judge Harry J. Elam. And fittingly, another founding father is our honoree here today, Justice Fred Brown. The conference was formed then and remains charged with today to support judges of color who are underrepresented in the ranks of the judiciary and who are appointed to serve in either the courts of the Commonwealth of Massachusetts or the United States courts sitting in Massachusetts, to educate members in the bar on legal issues of concern to communities of color, and to stand as a visible presence and voice on matters of justice and equality under the law and the larger legal community for people of color. This afternoon, we are so excited to pay homage to the spirit and historic career of Justice Fred Brown, the first African-American ever appointed to a Massachusetts appellate court. Justice Brown joined the appeals court in 1976, appointed by Governor Michael Dukakis, and following the retirement of Justice David A. Rose, at a time when the appeals court had 6 justices and an incredible backlog. He recalls entering fiery and eager to do justice expeditiously, proposing the Rocket Docket, a program which reduced oral argument and opinion length, thereby doubling the number of cases to be heard by the panel. Seated on the court for 27 years and serving as a recall justice for 12 years to follow, Justice Brown authored more dissents and concurrences combined than any other justice. And demonstrated candor, astuteness, and significant extrajudicial involvement along the way. His contributions to the court, conference, and Commonwealth are myriad and an honor to recognize today. In celebration, we are joined by members of the judiciary, important figures from the legislature, representatives of the Harry J. Elam Judicial Conference, and Justice Brown's former law clerks, some of whom have reached the level of the bench themselves, including the Supreme Court of Connecticut. Last but hardly least, our friends from Justice Brown's new home community in Lexington, Mass., and Maria Cardinal, Justice Brown's longtime chamber secretary. Additionally, I am pleased to recognize members of the Brown family in our company. Justice Brown's son, Albert Kip Brown, and his wife, Beth. Daughter, Allison, with her husband, Greg White, and their sons, Oliver, Lucan, and Max. And though his daughter, Elizabeth, was scheduled to be here today, unfortunately, she's a bit under the weather and couldn't make it, but we are grateful that her husband, Brian Madsen, is here representing the family. And I'm confident that Justice Brown's wife, Constance, his greatest supporter, and father, Edgar G. Brown, an equally passionate and influential civil rights activist, are watching from above and smiling down with an abundance of pride on this very special day. With that, I'm going to turn the program over to Chief Justice Mark Green, who will welcome you on behalf of the Appeals Court and offer some reflections of his own regarding Justice Brown's career on the court. Following him, we'll hear from, in order of seniority, Justices Rubin, Wolahogian, and retired Justice Maldonado, who will also offer brief reflections of Justice Brown in their time as colleagues on the court, with a special perspective from Justice Maldonado, who also served as one of Justice Brown's first law clerks. When she concludes, we will hear from the guest of honor himself, before we move to the moment we're all gathered for, the official unveiling of Justice Brown's portrait, and we'll have a reception to follow in the Rose Library. With that, Chief, I turn it over to you.
Thank you, Justice Desmond. It really is a distinct honor and privilege for all of us to be here to pay this tribute, long overdue, to our friend and colleague, Justice Brown. I was fortunate enough to join this court at a time when Justice Brown was still in active duty before he reached the mandatory retirement age of 70. And I overlapped with him, served together for 14 years, which still, if you can believe it, is just a small fraction of the total 39 years that he served on this court. With his statutory and recall service combined, he holds the distinction of serving on the appeals court longer than any other justice in the court's history, even including former Chief Justice Armstrong, who, as you all know, was one of the original 6 when the court was established. We are still a very young court. We celebrated our 50th anniversary last year around this time, and we are fortunate at our relative youth still to have first-person accounts of our early history from the legendary figures who built the institution. Justice Brown was to me, as he has been to so many of you in this room, a mentor and a friend and a vault of institutional memory. Memory being the operative word. He can recall cases with a level of detail and command that I've never seen among all the other distinguished colleagues with whom I've served. In fact, he reminds me regularly of cases on which we sat together on panel, of which I have no recollection whatsoever. It is a tribute to his legacy that so many of his former colleagues are here with us today. So many judges and staff who have made the effort to come back, some from quite a distance, and that is not just out of respect, but it's out of affection. And of course, I particularly want to acknowledge his former law clerk, Justice Maldonado, now retired, but who served as a justice on this court with distinction for many years before her too early retirement. Justice Brown is well known as a crisp and quick writer and thinker. He was relentless during his time as a justice of this court in his efforts to encourage parties to bring their best game, and particularly, and how can I put this delicately, in encouraging trial prosecutors to prepare well for their closing arguments. He is an archivist of oddities of the appeals court. He was quick to remind us if we were exploring the possibility of trying something different, that it had already been done before. In fact, if you don't believe me, look in Volume 5 of the Appeals Court Reports at page 296, Commonwealth versus Gray. We recently congratulated ourselves for convening an en banc panel to hear the case of Ferrara versus Charland. But if you look at the case report for Commonwealth versus Gray, you will see that all 6 of the then sitting justices of the court participated in that case. What is unusual about Commonwealth versus Gray is that the same author authored both the majority and dissenting opinions. Now that was not, let me be clear, that was not a sign of early schizophrenia. That was, in fact, instead, what I consider to be a rather unfortunate episode of hazing. Justice Brown was relatively new in his tenure here, and the panel chief said that case was pre-assigned to you, you're going to write it, whether you agree with it or not. So he said, okay, and I'll write that, and I'll write the dissent as well. Justice Brown also is fond of describing another incident of what I would call early hazing. He was sitting on panel, I believe it was with Chief Justice Hale. He'll correct me if I'm wrong. And he worked hard to produce what was a very fine 30-page draft. And when it came back to him from his panel chief, he said, "Yeah, this is pretty good. Make it a rescript." And he did. There's nothing that you can't say better with fewer words. He's well known for his often repeated quotes, "Get out of Dodge." That was when you were in the other court, now you're in a real court. Or in kindly recognizing or generously recognizing the error of a trial judge that we needed to reverse, he'd say, well, the good judge had a bad day. It gives me great pleasure to know that his image will grace these walls, and along with the thousands of opinions he authored in the bound green volumes, that it will serve as a lasting, tangible reminder of the legacy he leaves on this court. Congratulations.
Thank you so much, Chief. As I said, we're going to hear from the speakers in order of seniority. So, Justice Rubin.
Thank you. Associate Justice Frederick L. Brown served on the Massachusetts Appeals Court for almost 40 years, from his appointment in 1976 until his retirement as a recall justice in 2015. No more brilliant or courageous a judge has ever sat on this bench. No judge's intellect was sharper or more precise than Justice Brown's from the day of his arrival until the day of his retirement. Though, as I will discuss, I don't think that that is the most important characteristic he brought to the job. His remarkable achievements before taking the bench are testimony to his extraordinary brilliance. He graduated from Harvard College cum laude in 1954, one of less than 10 African American students in his class. He served in the United States Army for 10 years, and in 1964, he entered the Harvard Law School, graduating in 1967. Again, of the 519 people in his class, less than 10 were African American. In 1976, Justice Brown was appointed to the appeals court by Governor Michael Dukakis. Justice Brown was the first African American appellate judge ever appointed in the Commonwealth. No African American would be appointed to our state Supreme Court for another 20 years. I've never heard Justice Brown even mention it, but to have succeeded as he did, to have risen through the ranks to the top of the academic and legal worlds as he did, faced with the obstacles and racism he faced, particularly in the city of Boston at that time, is a remarkable testament to his character. Justice Brown's decisions once on our court were characterized by his brilliance and insight. Having sat on well over 3,000 cases, Justice Brown's influence can be seen in all areas of the law of the Commonwealth, but I will address 3 areas in which I think his work was of particular importance. First is the question of the discriminatory use of peremptory challenges. In a much-cited law review article in 1978, Justice Brown and two co-authors wrote that peremptory challenges by prosecutors should be abolished. The Supreme Court subsequently declined to abolish them in Batson versus Kentucky, which created the framework we now use for assessing them. Justice Thurgood Marshall, though, concurred in that case, citing Justice Brown's article in his opinion and calling for the abolition of peremptory challenges altogether. In Commonwealth versus Harris in 1990, a panel of our court applying Batson upheld a prosecutor's use of a peremptory challenge against the only African American on the jury panel in a case with an African American defendant, accepting what really amounted to a flimsy make-weight argument by the prosecutor of the alleged non-racial reason for his challenge, essentially that the witness reminded the lawyer of the defendant's mother, another black woman. Justice Brown dissented. He wrote, "Because of the prosecutor's shameful and flagrant misuse of the peremptory challenge to exclude a juror solely on the basis of race, the defendant did not receive a fair trial. I am shocked that in this day and age, prosecutors are still challenging persons peremptorily for no reason other than their ethnicity. This is improper and immoral, apart from being unconstitutional." In that case, as in many cases in which Justice Brown wrote a dissent, the Supreme Judicial Court took the case and reversed. Second, his opinions demonstrate deep concern with the ethics of the legal profession. Thus, in Delory versus Delory in 1986, in which an associate from a firm represented the husband in divorce proceedings, despite another attorney from the firm previously having represented the wife, Justice Brown concurred, writing, "In my view, it would not lie in the mouth of an attorney, an officer of the court, to plead that an action is proper simply because no canon or disciplinary rule explicitly proscribes it. Professional responsibility is something that cannot merely be taught in law school and tested on a multiple choice examination. It is an ethic that must be nurtured and cultivated by every attorney during the entire course of his or her professional life. We must stake out the moral high ground by demanding sound and ethical judgments from our brothers and sisters at the bar. I think it is important to assert that avarice must not be allowed to consume our profession." Similarly, in Nova Assignments versus Cunean, Justice Brown, concurring in an opinion that I wrote, actually, wrote, "The attorney-client privilege should never be used to shield deceptive practices. The manners and morals of the marketplace have no place in the legal profession." Finally, and relatedly, Justice Brown is renowned, as has been mentioned, for his work trying to ensure that prosecutors in particular adhere to the high standards expected and required of them, particularly with respect to closing argument. As long ago as 1985 in Commonwealth versus Kozik, concurring in an opinion by Justice Graney reversing a conviction, he wrote, "It is patently obvious from the majority opinion, in which I fully concur, that the principal errors the defendant claims occurred at trial could have been avoided by a prosecutor who was striving for a fair trial. The closing argument was unfair and unprofessional. Here, 15 minutes of thoughtful and careful preparation would have saved the Commonwealth much time and expense. The admonition not to sail unnecessarily close to the wind is in direct response to such careless overreaching in final argument. It cannot be gainsaid that proper as well as effective argument requires careful preparation." And in 2000, he wrote, "Once again, it is patently clear that some prosecutors are completely ignorant of our appellate court's admonitions concerning closing argument. They are either unable or unwilling to steer their closing arguments within permissible bounds. Without rehearsing the painfully long list of flagrant violations, I repeat my message to the Commonwealth attorneys. If the assistant district attorneys cannot get it right, get new assistants." What unites Justice Brown's decisions in these and so many other areas of law really is not their subject matter or the incisiveness of his legal reasoning or prose. It is that in them one can see not only Justice Brown's intellect, but his passion for justice. For that is the other, even more essential characteristic that made him such an outstanding judge. It's an honor to have been asked to pay tribute to Justice Brown at these proceedings, but it is one of the great honors of my professional life that I had the opportunity to sit with him as a colleague, and of my personal life, that I can call him a friend.
Thank you, Justice Rubin. Justice Willa-Hoji.
Good afternoon. It is as much a pleasure as it is an honor to say a few words today about my friend and former colleague, Justice Fred Brown, as his portrait takes its place on the walls of this court. Judge Brown, as we all know, was a first-rate judge of remarkable tenure, intelligence, vigor, and integrity. For those reasons alone, he stands among the best of our alumni whose portraits already hang in this court. But Judge Brown's portrait has a special additional significance because his professional accomplishments were earned against the headwinds of discrimination and systemic racism. Through sheer dint of talent, hard work, gumption, and determination, Fred propelled himself to Harvard College, to Harvard Law School, to the military, to government practice, and ultimately to the Massachusetts Appeals Court, where he became, as we have already heard, the first Black appellate judge in this Commonwealth. This extraordinary trajectory was most certainly not a foregone conclusion, given the times into which Judge Brown was born. Indeed, Fred himself took part in the struggle against Jim Crow laws when he was young, along with his father. As Newsweek reported in 1949, Fred, along with his father, staged an 8-hour sit-in at the lunch counter at National Airport, where, I add, they were never served. It is almost impossible to describe the magnitude of Judge Brown's contributions to this court. To put the length of his service in perspective, in 1976, when Fred was appointed to the bench by Governor Dukakis, I was 15 years old. When Fred retired, unwillingly, in 2015, I was 55. It's a lifetime. He, by the way, at that point still looked 45. He was a judicial beast. He sat full sittings for decades, often volunteering for extra work, including during the summer, although it must be confessed that he had a special willingness to volunteer for summer sittings in the Berkshires. He sat with every judge appointed to this court before his departure, and he wrote thousands of decisions. He was indefatigable. Even when seated at his desk, with books and yellow pads spread in front of him, you could sense Fred's energy. Judge Brown had an encyclopedic knowledge of the law and an extraordinary memory. Who needed Westlaw? Straight from his head, Fred could reference hundreds of cases by citation, or by their facts, or by their holding, or by their author. He was always prepared for argument and usually loaded for bear. He was prompt with his decisions. He took to heart the maxim that justice delayed is justice denied. His comments on second panel were returned within 48 hours of the draft being circulated. These he would deliver in hand to your office with a quick word of encouragement, or a citation or two you had missed, or a point he thought you could add. Or, if he thought you were wrong, he'd tell you that too. Over the thousands of cases on which he sat, I don't think he ever lost his energy or enthusiasm for the job. He loved being a judge, and he relished the responsibility and power that came with the position. Fred strove to use that power to make a difference, as you heard in some of the cases that Justice Rubin just quoted. And he did so whether he was writing for the majority or in dissent. I met Judge Brown when I arrived at the court in 2008. At that point, Fred, along with Raya Drebin and Chris Armstrong, was on recall which meant that I and the other new judges got to sit with and learn from judges of tremendous experience and wisdom. What a gift to all of us that system was. Although Fred was not my mentor, he took me under his wing, probably because his small, windowless office was just across the hall from my small, windowless office, and I no doubt looked like I needed a lot of help. Fred would pop in almost daily. Sometimes it would be to drop off comments on one of my drafts. Sometimes he would stop in to tell me about the judges he admired, such as Rubin Goodman. Fred valued many different qualities in his colleagues, but his highest admiration was reserved for people whom he considered to have a conscience. He had no tolerance for phonies and even less for pretense. He admired excellence. This meant that high praise was reserved for people he considered, quote, the real deal. To give you a sense of how high that bar is, he recently described Beethoven as the real deal to me. I think we can all concur on that one. Fred also had many views about judicial opinions. He was critical of poorly written opinions, and he had little use for opinions that could not, as he called it, be taken to the bank. As I came to understand this phrase, an opinion could be taken to the bank if it was completely honest in all senses, not only to the law and to the facts, but also to what is right and fair. And as I sit here today, I would be hard-pressed to come up with a better definition of what we should all be aiming for in our careers. Judge Brown's departure from the court was a moment of personal sadness for me and many others. Among the most memorable moments I have had on this bench were when Judge Brown was sitting right wing, I was on left wing, and the poor judge playing center was trying to keep us from going off sides. I miss those days. More importantly, though, Judge Brown's departure was a huge loss for this court, not only because he was an extraordinary judge, but because his appointment as the first Black appellate judge in Massachusetts represented an important milestone on our collective path towards justice. I hope that his portrait will serve not only to remind us of him, but also of the work that remains undone to see his legacy fully realized.
And now we'll hear from Justice Maldonado.
Justice Brown, I would first like to publicly thank you for giving me the opportunity to serve as your law clerk on the Massachusetts Appeals Court nearly 40 years ago, at a time when not too many judicial law clerks looked like me, sounded like me, or shared in my educational background. Because of your understanding of how a judicial clerkship is a gateway to a flourishing career in the law and a way to diversify the profession at the higher ranks, you put talent and promise above prestige and created opportunity for those of us that might otherwise have been overlooked. You singularly created opportunity for a long line of Black, brown, and female law graduates, including myself, who otherwise might not have had as many doors open to us. And for that, I am truly grateful. But I was asked to speak on what it was like to clerk for you. Let me say first, it was a lot easier to clerk for you than when I first had to appear before you. I remember it like yesterday, Commonwealth versus Abreu. I, like so many of the other litigants appearing before you, shivered in my high heels, not boots, even though I knew what to expect. But I remembered what you taught me, both in your words and in your actions. Preparation, preparation, and more preparation. And so, less than a minute into the argument, those shivers quickly melted away. I lost that case, but I knew how not to fumble. You also taught me, whether it be an oral argument or in my written expression, to be convincing, you must be concise. In your mantra, do not say in 20 pages what you can say in 10, and then whittle those 10 down to 3. Now, Judge Brown and I didn't talk much before he gave me an assignment, and I wore my head proudly that my judge was giving me all this latitude until I got my drafts back. I would research and print out tons of cases, read them, highlight them, and quote as many as I could in these lengthy drafts. Poor Maria, the judge's secretary. In an age before computers and word processing, she would manually type pages of a handwritten draft, only for the judge to redline it and cut it and shred it to pieces. So much for great latitude. For him, it wasn't in the talk, it was in the doing. So I kept doing and doing, he kept correcting and correcting until I got better and better. And in the end, while other lawyers were beating down the doors to the State Public Defender's Office, the Committee for Public Counsel Services, to get hired in their coveted appellate division, CPCS came knocking on mine. Justice Brown, I owe that opportunity and all that flowed in my career thereafter to your tutelage and the chance you took with me. I entered your chamber thinking I wanted a career in tax law, but it was your inspiration and guidance that set me on a path to more closely related law in giving a voice to the underserved and preserving and protecting our Constitution. In the year that I clerked, Justice Brown was the most talked about judge among the law clerks. He was the superstar, at least that's how I viewed him. We talked about how he wrote more dissents than any other judges on the court, because, as many of us had said, he was the conscience of the court. We talked about his willingness to tell it like it is, even in his written decisions, with lines like, ethnicity plus velocity do not equal probable cause. And in referencing the crime show to Beretta, don't do the crime if you can't do the time. And well before the Me Too movement, in the 80s, no means no. We watched in awe as he would pull a reporter off the shelf during oral argument and beeline straight to the page and language of an on-point case missed by both parties. But to me, he was more than a mentor and a judicial icon. He welcomed me into his home and into his family. I graduated from Northeastern School of Law with my friend and his daughter, Allison. I had already been hired by the judge by then, so I made sure to introduce my parents to the judge and his wife at graduation. In turn, they invited us to Allison's graduation celebration at their home that evening, which we excitedly attended. When the evening closed and we were saying our goodbyes, my mother, who was old school, didn't speak much English, and had a heavy Latina accent, turned to Justice Brown and said something like, "My daughter, now she's going to work for you. I don't live here in Boston. You take good care of her, and you make sure she work good for you." I was mortified. Justice Brown, however, simply smiled and nodded yes as he shook my parents' hands. Meanwhile, his wife, Connie, folded my mother's hands into hers, leaned in and said, "Mrs. Maldonado, do not worry. We will take good care of your child." And that they did. That summer, I was invited to the Browns' summer cottage in Vermont. I watched as the judge pored over red and blue-back briefs at the breakfast table while the rest of us headed to the hot tub or beach. I hadn't started at the appeals court yet, but I got a glimpse of what was in store for me. I was invited to art shows at Connie's Art Gallery, family events, and even Thanksgiving and Easter dinner. I recall that Easter, after dinner, Justice Brown and Connie called us out to the yard for an egg hunt. And I thought, an egg hunt? We're in our mid-20s to early 30s, and too old to be chasing after jelly beans. But when the judge calls, you answer. So out I went. Much to my surprise, we weren't running after pastel-colored eggs filled with candy, but rather tiny little wine and spirit bottles beautifully wrapped in colorful tissue paper and curly ribbons. It was a whimsical side of the judge that most people do not get to see. I was proud to serve as Justice Brown's law clerk on the appeals court, but even more proud to be able to come back to the court and sit as a colleague by his side. In fact, I said to Governor Patrick when I met him during the application process that one of my reasons for wanting to leave the district court for the appeals court was to be able to serve alongside Justice Frederick L. Brown, my first mentor in the legal profession. And I'd like to believe that it was that statement that sealed my appointment. Now, I'm not going to repeat to you the precise language the judge used when he learned of my nomination and appointment, but let's just say he was thrilled to have had nurtured, encouraged, and taught and supported the first Hispanic appointed to any of the state's appellate courts. I have had several memorable sittings as a justice of this court, but the first of these was the first time I was assigned to a panel with Justice Brown. Justice Graham was middle chair, Justice Brown was on the left, and I, the younger judge, sitting as I am here on the right. In one of the cases, a young lawyer began his argument saying, "Let me explain to the court what goes on in the district court and how things are done in the district court department." Judge Brown couldn't contain himself. He quickly interrupted and, bearing a big smile, said, "Counsel, you obviously didn't do your homework on the background of your panel. My esteemed colleague here, Justice Maldonado, is a 15-year veteran of the district court department. I don't think you want to be schooling her on the workings of the district court." The lawyer turned beet red and quickly moved on to the rest of his argument. Justice Brown, you have given so much to so many in so many ways, and you continue to do so to this day. Just a few months back, I witnessed your grandson driving you to Brockton to give a talk to youth at the community center there. By the commission and unveiling of your portrait, today's recognition of your esteemed career and your great contributions to our community and jurisprudence and our legal profession is long overdue. But I am delighted that this day is finally here and honored to be able to sit here with you in it. Justice Desmond, thank you for spearheading these efforts. And finally, Fred, I want to thank you again for your friendship and your support. You hold a very special place in my heart. Congratulations. I wish you and your family all the best.
We will now hear from Justice Brown, who I will share with you turned 90 years old this year. There's no doubt he is an excellent judge, but to me he is a giant of a man. Justice Brown.
I'm going to have to go off script first to say that Judge Wollenhogen, she talked about the conscience of the court. She is now the conscience of this court. And Judge Rubin, one of the last cases I had, Judge Maldonado was on the panel with me and Judge Rubin, so he didn't have a chance because there were 2 votes against him before we even started. But he wrote a brilliant dissent. You can see why I asked these 2 to be here. They say all these things. Don't believe any of that, but But anyway, I won't talk about anything in particular, but I would like to stroll down memory lane. Now, my daughter says don't go too far down memory lane because some of these people weren't born when you were a judge. But my first experience in the appeals court was when I went to see Judge Hale, whose picture I think is still back there. They may take it down, but they shouldn't. He's a great man. And he said to me, "Walk with me." And he walked me down the hall, and he stopped in front of my office, and he pointed to the name plaque. And he said, "You see that?" And I said, "Yeah." He said, "That reads exactly the same as every other judge's plaque on this court." And that was the way it began. And then he said, "Check with the clerk, pick up your cases, be here at 9:30 in the morning, and wear a white shirt." That was my orientation. I didn't even know where I was. But the other thing, I'll circle back. When I was being sworn in by Governor Dukakis, I observed immediately that there were no women on the SJC, the Supreme Judicial Court, and there were no women on the appeals court, and I think only maybe one or two on the Superior Court. So I thought that was a little awkward and needed to be corrected, and so I said, "We should get this squared away, Governor, right away." And lo and behold, there they are on the wall there 4 years later. Judge Peretta and Judge Drebin came on the court. But then, the most historic moment of all was years later, when there was a panel of all women, the court clerk was a woman, and the two court officers were women. That was a historic moment. So that was real progress. But now I want to give a shout out to an audience of one. When I came on the court in 1976, there were 6 judges, and I was a Lone Ranger. Now, almost 50 years later, there's still only one ranger. So I think the governor, if she's listening, might be able to fix that. Then I think, I shouldn't say this, but I think all my colleagues have already taken all my lines, but I just wanted to repeat 2 of my greatest hits. I think you heard one already, and that is, ethnicity plus velocity does not equal probable cause.
Amen.
I think some of you know what that means. But the other one, on the civil side of the law, is something that I felt very strongly about, and I think still goes on today. And that is, the law should care as deeply about helping the needy as well as protecting the greedy. And that still stands, I think, today. The needy need help, and we have to stop protecting the greedy. And I think we see a lot of that today. But one thing I want to mention that no one ever mentions, and that is, you see all these wonderful portraits on the wall. There could be some people who should be on the wall that probably never will be. And those are the staff attorneys and also the other members of the staff. Those are the people that keep the train on the track. Those are the people that make sure and help us to get it right. And that's really important. We really do try to get it right. And those are people that contribute greatly to that. And finally, sort of one fun thing I'll say before I finish. Former Chief Justice Liakis once asked me to speak at a conference, and at the conference were all the Supreme Court justices, all the appeals court justices, many Superior Court justices, members of the bar, and the public. And in the course of those remarks, I said, the Supreme Judicial Court is the greatest court in this nation, but the appeals court is the finest court in the building. It is my honor and my privilege to have served 39 years on the Massachusetts Appeals Court. It was a real pleasure, and I had a great ride, and I had great colleagues. So at this stage, I think there's only one thing left for me to do. As Barack Obama would say, drop the mic.
Portrait that we have over here to the left, but hopefully the next time you come in this courtroom, you'll see the portrait prominently displayed on this wall to the right. So that concludes today's ceremony. Thank you so much for coming from near and far to be in attendance. It's a great day for the Commonwealth, and we're proud to be here and be a part of it. We'll be hosting a reception in the Rose Library, and we invite you all to join us there. Thank you.